International Law Department under the Office of the Attorney General deals with international engagements with government partners on various issues.
This department assists government ministries and agencies in terms of provision of legal advice whenever they're engaging with international partners or international organizations, if I may put it that way. So whenever a ministry wants to conclude an agreement or a treaty, we are the ones now who come in to advise as the principal legal advisors of government. That could be at a bilateral level between us and another country or us and another international organization. It could also be at the regional level. So if Kenya is, for example, we're members of the East African community, and whenever there are any negotiations taking place or meetings of the East African community, we participate as the legal advisors. And the reason we participate is so that we can be able to advise the delegation that is attending those meetings to ensure that they are complying with our laws, to ensure that we're complying with our policies whenever we're engaging in any discussions, so that they do not go outside and conclude something that would be unconstitutional for us or against our laws and against our policies. We also do the same when it comes to international meetings, and those are now what we refer to as multilateral engagements, and those are the United Nations or any other multilateral institution that we engage ourselves in. We play the same role. We are part of the delegation that goes to negotiate, and we help them understand whether they are going outside of the law or not. We also sit in legal committees of those international institutions and articulate our legal position as a country. So we sit with our peers and we negotiate and iron out what we think would be in the best interest of Kenya and what would be still legally acceptable.
It is this unit that negotiates, vets, and drafts international legal instruments that govern the relationship between Kenya and its partners.
Now, some of the engagements that we have led to completion or conclusion of international treaties. At the regional level, we must say, right from the beginning of the East African community as we know it today, we participated right from the treaty that establishes the East African community and all other protocols and laws that have been set up under the East African community. We participate also at the COMESA level. We participate in the tripartite that we might be having between SADC, COMESA, and the EAC. We also participate at the African Union, and when I say we participate, it's in terms of trying to advise on the legality of those documents. They must come to us for us to clear them, for us to vet them, and then we now pass it on now to Foreign Affairs to play its role in terms of the signing of those documents. All of this is guided, of course, by our laws, and in particular, it's the Constitution. We also have what is known as the Treaty Making and Ratification Act that spells out how we go about that process before Kenya becomes party to those treaties.
These partners could be sovereign countries, intergovernmental organizations, or a multilateral engagement with other countries.
So the department is also engaged in what is referred to as international judicial cooperation. What this means is that we try to facilitate when Kenya is requested in terms of judicial cooperation. Now, judicial cooperation would entail what might be referred to as mutual legal assistance. Should Kenya receive a request from another country to assist in terms of investigation or any other matter that is being considered at a criminal level, then we are supposed to assist them. This is governed by the Mutual Legal Assistance Act that was passed in early 2013. The Attorney General is the central authority under the Mutual Legal Assistance Act. That means that another country that is seeking to be assisted in any criminal matter has to write to the Attorney General, and the Attorney General examines that request whether it meets all the criteria set out under the Mutual Legal Assistance Act before he confirms that he's able to give that assistance. If it does not, then he returns that request to the country. Mutual legal assistance is also enhanced by what is referred to as extradition. If we do not have an extradition treaty concluded between ourselves and the country that is seeking that extradition, then we are not obliged to extradite the person that is sought. It takes a longer route that we must go through foreign affairs, we must go through our courts, we must go through, it's a long process. So it helps that Kenya concludes a treaty, an extradition treaty with another country that eases the process.
Since the department is not public-facing, it works closely with government institutions whenever they have engagements with international partners. To do this, the process is generally initiated by the department that needs assistance.
So normally a ministry will write to the Attorney General, setting out what the issue is. If, for example, it is an interpretation of a document, they have to set out what the issue is. We undertake our research. We are able now to form an opinion and write back to that ministry to tell them what steps they need to take in order to be compliant with our legislation and with our constitution. If it is a negotiation that they want to undertake, it is a long process. A negotiation takes several steps before it is finally concluded. We start from the inception of what it is that we think is in the interest of Kenya. We advise them along the way until such time as they are able to conclude it, and we say Kenya is ready to sign on to that legal instrument that we have been negotiating over time. This process might be different. If, for example, we're looking at an MOU between ourselves and another country, the ministry will have tried to spell out what the thematic area is. Then we sit down and look at the provisions of that MOU and ensure that they are compliant with our objectives and our interests as a country. Then in that case, we tell the ministry, we have looked at the draft, we have looked at the law, and we feel that it is compliant with our laws. So every legal instrument can differ depending on the complexity of what is being negotiated with the other countries or with our partners. An MOU might be simpler if it is covering just a technical ground. But if it comes to a treaty, because there are many interests that are at stake, then that one would take a lot longer. But we know at the end of the day, we're still the ones who are providing the legal advice on the legalities of what it is that we're discussing.
International arbitration usually costs the sitting governments a lot of money. The department, however, has been trying out creative ways to ensure that the most amicable and cost-effective means are used to settle the disputes.
Generally, arbitration is meant to be faster and friendly. It's not as adversarial as if we were going before the court and having judges determine for us the dispute. However, as it is today, there has been determined a need to revise or to reform the rules that govern investment dispute settlement mechanisms, because we're finding as a developing nation that it costs too much. One instance or one arbitration alone could cost Kenyans $500 million and more to defend it. That is money that is not available readily, and that is money that should otherwise be used in our development of our infrastructure, of our education, of our health system, rather than being directed towards defending one case. So we are participating right now in some United Nations reform talks. There is a working group where we've been participating from 2018, trying to ensure that our voice is heard as a developing country. Now, when it comes to international litigation, there is a law that governs our relations with other countries. And we also try, under the UN, we are required to try and ensure that any dispute arising between ourselves, between Kenya and another country, are resolved as amicably as possible. That means we engage our diplomatic and political relations with that country. Where it fails to do that, as has happened in one instance, that country takes us to the International Court of Justice. That is really regrettably.
The department has successfully handled a number of cases which they are proud of.
National Center for Settlement of Investment Disputes, which is commonly referred to as ICSID, which is a World Bank creation. And under that one, we have had 2 cases actually in the recent past where Kenya was sued for really what I would call preposterous amounts of money. We're talking about billions of shillings, which were exposing Kenya in terms of, had we not successfully defended those cases, we would then have been obliged to pay those amounts of money. We, on the other hand, have private, other investors who opt to take the arbitration to other forms of tribunals that are not governed by ICSID. And those, unfortunately, again, like I said, are really confidential. We're not even able to disclose to you the details under which the dispute arose. But like I said, by and large, arbitration, international arbitrations, require that you have tried to first of all settle it locally before now you refer the matter to the international tribunal. I think everything we do is a success. You see, when you're the principal legal advisor, you offer your opinion, your professional opinion on the matter. And that would mean that the ministry or your client takes it on and does exactly what you're telling them, or it stops them from where they wanted to go if it was going to be illegal. So in that sense, I would say whatever we do every day is still a success. You're helping the government to function the way it is meant to function under the laws. What I would say probably, and what might be of interest now to the public, would be that we are not able to articulate some of the matters we get into because of the confidentiality. Particularly when it comes to some of the negotiations, we're not able to share what it is we're going to discuss. But finally, the outcome would be a concluded document that is available in the public domain. That is how you're able to now see that that is our success. That could take a while before you finally see the completed document. When it comes to arbitration, again, those are very confidential, and both parties sign that they cannot offer any information on the arbitration matters. So without the express authority of both parties recorded before the tribunal or the court, we're not able to share some of those